Okay, welcome back everybody to the next session for the Middle East Investment Summit. This panel is entitled Ensuring Compliance with the EU's Economic Substance Requirements. For that, I would like to introduce you to our moderator for today, who is Michael Fay QC, a partner from Aegon Litigation. Michael, over to you.
Thank you very much. Good morning, everybody, and welcome to this session on ensuring compliance with the EU's economic substance requirements. I'm joined this morning by a panel of 4 experts in the area, and before we start, I'll briefly introduce you to each of them. The first member is Charlotte Bailey. Charlotte is the Managing Director of TMF in the BVI. She read law and business at Queensland University of Technology and was admitted as a solicitor in Queensland, and she's also a chartered company secretary. She spent the last 15 years working in financial services industry. She's a well-known figure in the BVI. She's a director of BVI Finance and is the current president of the Association of Registered Agents in the BVI. Secondly, I'm joined by Warren Luyt. Warren is the managing director of Trident Trust and will be well known to those of you resident in Dubai. He holds a Bachelor of Arts and a Bachelor of Laws and a higher diploma in labour law. In addition, he's qualified as a solicitor, admitted as an attorney in South Africa, and he's a member of STEP, and he was the chairman of STEP Arabia. Thirdly, I'm joined by Josh Mangeot. Josh is a solicitor in the Harneys BVI transactional team. He trained with Slaughter and May in London and undertook a secondment at the Financial Markets Law Committee established by the Bank of England. He has a broad corporate practice and is generally recognised as an expert in the BVI on economic substance. He was involved in the design of the somewhat innovative online classification solutions developed by his firm Harneys. And finally, I'm joined by James Barnard, who is the European representative of the DMCC based in the Netherlands. He's been with the DMC since 2006. Prior to that, he owned and operated a group of companies producing and trading in physical commodities and derivatives. He has a particular interest in blockchain as responsibility inter alia for the development of a crypto ecosystem in Dubai. So that's our panel this morning. And perhaps I can start off by asking Josh to give us a broad analysis of substance requirements in the BVI.
Sure, thank you very much, Michael, for that introduction, and welcome everybody. And I'd first like to just thank all the other attendees and also BVI Finance, who are sponsoring this event and invited us to speak. So I think viewers will be pretty familiar with the story. Alongside all of the other international financial centres, the BVI in 2019 adopted economic substance requirements at the behest of the European Union and the OECD. And for a jurisdiction like the BVI, we are the world's leading incorporations jurisdiction internationally. We pride ourselves on efficiency, the stability of our products, our deep experience of our financial services sector, and really being able to offer clients a really efficient and smooth service. So for us, a big regulatory change of this type that affects the entire jurisdiction and all of our many companies is, a major event, and it's something that we want to help the market through. So the last 2 years for me personally as a lawyer at Harneys have been extremely busy working on that. The start of this, of course, was the introduction of our legislation, which came into effect on the 1st of January 2019. And there was a 6-month transitional period that was allowed for all the pre-existing vehicles that were registered in the BVI at that time. That had to end by the 30th of June 2019. And then the first 12-month compliance phase started for the majority of BVI vehicles. That ran for 12 months, as I said, and then there was a 6-month reporting window, which really takes us to up to where we are now, which is in the end of the first reporting cycle for most BVI companies. I think it's important to note that none of the deadlines around this were extended because of the COVID pandemic, which I think a lot of people had hoped that the OECD might step in and push some of the compliance deadlines out. That didn't happen, so we're still on the same timetable. But I think it's real testament to the hard work of the BVI financial services sector and also the government, frankly, that they've managed to rise to the challenge, and that we're now in a position where we are preparing clients for the first reporting cycle. So that's really where we are in the BVI.
Okay, and has your experience been that that most people have been able to comply? Most of the companies have complied, and that that things are looking positive in that respect?
Yeah, absolutely. It's very, I mean, it's important to recognise with economic substance not every vehicle is affected, either because it's not carrying on relevant activity at all, or because it's exempted because it has a foreign tax status, which makes it a good taxpayer for all intents and purposes. So for those ones, it's very straightforward. For pure equity holding entities, that's our definition of holding business. Again, the compliance is not onerous. It's straightforward. Then you move into some of the more classic legacy structures associated with BEPS and some of the more what I would call the active relevant activities in the book. And then at the end of that spectrum, you have IP business. So it really depends on the specific business and how they fall out. And I think one of the challenges of the last 2 years really has been educating the market that is the case. And speaking to clients to go through a review of their structures and make sure that they're still fit for purpose. So the answer to your question depends on the client, but yes, for the vast majority, it's been heartening to be able to help with compliance.
Thanks, Josh. I'm going to come to Charlotte in a moment and ask her about some of the practical implications of how economic substance has been incorporated in the BVI. But before that, can I ask you, Warren, to give us some input as to how you've seen this panning out from Dubai?
Yes, thank you, Michael. And again, also thank you. A great privilege and honor to be invited into this panel. I've had a long-standing relationship with the BVI. Been in Dubai now 15 years, and we've been working extensively with BVI since 2006, since when I've arrived here. Yes, it has been an interesting ride. We have been fortunate in that we have a large portfolio of companies established outside of the UAE. And in most of those jurisdictions, the legislation and the guidelines and regulations were available prior to them becoming available in the UAE. So we had to learn all of those jurisdictions first, and then unlearn a lot of those concepts by getting to know the UAE version of that. And I think a fact that is quite often overlooked is that I think that the UAE is most probably the only jurisdiction which is effectively a civil law jurisdiction where this project has been implemented. And people sometimes do not understand the differences in how an activity relates in a civil company documentation, especially as opposed to really the open nature in an objects clause in a common law company. So I think we kind of were a little bit further along the road, and it was easier for us to implement the program. But yes, it was a lot different. We were quicker to the first notification, which happened on the 30th of June, which now appears as from the 19th of August, we've received the third version of the legislation here, and that effectively has been our practice run. And we're going to then file again before the end of the year. So there has been a lot of differences. There is certainly differences in definitions, which is taken up a huge amount of our time and effectively spent a huge amount of time trying to work out exactly whether people were conducting relevant activities or not. But eventually everybody did make their filings, and people in this part of the world are relatively au fait with economic substance, having already filed all of their documents to date. I think fundamentally we are very different to the BVI in that we are most probably 40 plus different jurisdictions, all with their own registrar, all with their own implementation rules, and that makes it so much more complicated for us in this part of the world, because every registrar was also trying to work out what was going on and how to implement it. So that was a big difference. We've also ended up at the end of the day with quite a different system, in that there's really a sort of three categories of companies: those that fall out of or do not conduct a relevant activity; those that do conduct a relevant activity, which do not receive, have not charged income in the financial period; and those which are conducting relevant activity and did charge income. And those are three different separate filings, or dealt with in different ways, whereas the BVI is really just dealing with one filing at this point. So procedurally there's different, and interpretation there are differences. But effectively, I think everybody is trying to achieve the same end, and that is the mischief that the legislator is trying to remedy in ensuring that the relevant income from a specific activity is related back to the proper jurisdiction.
That's right. And has your experience been that clients have done their best to comply with this, or has there been resistance from clients to compliance?
I mean, there's been an evolution, and I think there will be a continued evolution of the jurisprudence in this, as everybody learns and understands, to harmonise all the jurisdictions into one direction. Initially, all the regulators in this part, or what was known as competent authorities, took their view that everybody should file. And so every company has had to file by the 30th of June, and we have seen a massive compliance. Everybody has done that. The new regulations are going to require that only those that are conducting a relevant activity need to file. So there has been a progression in that regard. But yes, everybody has, just like with COVID, we take everything very seriously here, and everybody is very compliant.
Okay. Thanks very much, Warren. Charlotte, can I turn to you then? Can you tell us how the BVI has gone about, as a matter of practice, implementing the requirements that have been imposed on it by the EU?
Yes, thank you, Michael, and yeah, welcome to everyone, and thank you very much for having me on this panel today. I suppose from my perspective and in the role that I sit in, I've been very heavily involved in, the development of the legislation and the practical implications for registered agents and clients. So what I have seen, the BVI once again responded extremely quickly, in terms of reacting really to, the requirements coming down from the EU. So that was fantastic. We had a large consultation with the industry, driven and supported by BVI Finance, where we developed working groups around the different types of relevant activities, and discussed and implemented, and generally just helped registered agents as well navigate their way through what clients would have needed to do to satisfy substance requirements. So that was a really great initiative that sort of brought the industry together, try and implement this consistently and as practical as possible. We also obviously work very closely with the ITA, in the International Tax Authority, and as well as the local law firms, to make sure that the legislation, when it was developed, was able to be implemented in a easy and practical way. So basically, what I have seen happen, that it's actually allowed, I think, the territory and registered agents to develop deeper and sort of more substance in terms of their client relationships, because we've had to not just be a registered agent, we've had to be more than that, and help our clients navigate through that. So I think for the territory overall, it's really boosted that type of level of client interaction and service provision that which we didn't really necessarily have to do before. So that's been absolutely fantastic. I think from a sort of a global point of view, it's really important to note, I think, that the OECD is really looking for global compliance, and it's not just the BVI, obviously, that has economic substance requirements now. It is the other overseas territories and crown dependencies, but I think what it does for the BVI is really sets itself apart in terms of what it was different before. So it's really, I think, boosts the reputation of the economy and what we're doing here. So it's a really good news story at the end of the day. What we also have done amazingly, I think, is the reporting framework that we have in place. Maybe a lot of you know the BOSS system already that BVI has, and that's what we use to report beneficial ownership on. But it has been developed to also do the reporting for the economic substance, which actually has been another really good news story or win for the BVI, because obviously we were used to using the system already, and clients are familiar with it. It's extremely secure, and the information is shared only when it should be with the relevant authorities through appropriate requests. So I think the use of BOSS for the economic substance reporting requirements has also, you know, seen us, you know, in the international arena really stand out compared to what other jurisdictions have been able to produce. So that's been fantastic. Registered agents are obviously responsible for the filing, and they have direct access into that database to respond, collect the information from the clients, and report to the government. So that's been really, really great as well. So I think overall, you know, economic substance has been really, really great for the territory. On a practical level, registered agents have seen, I think, a boost in terms of their client relationships and having to work with clients to, you know, implement the substance requirements, as well as internationally. You know, the BVI is definitely standing out in terms of its reporting requirements. So overall, yeah, a really good news story.
Thanks, Charlotte. Can I come to you, James? Can you tell us a little bit about the practical experience in Dubai and possibly in the wider UAE with the implementation of these requirements?
Thanks, Michael, and also thanks from me to BVI for having us on this event. So yeah, we've been involved from the very beginning. We were one of the free zones who was on the committee and involved with the various ministries throughout the UAE to get the regulations in place. And I'd say that we've been striving forward to really make our members aware of what's going on. I think the regulations that come in place are well placed. As Charlotte said, it's kind of about reputation, and we all want to have a good reputation and attract other companies to come to our different jurisdictions. I'd say the issues that we face are really to educate the member companies and the companies throughout the UAE of exactly what they are committing to and whether they opt in or opt out now. As Warren said, initially everyone came into the system to then say whether they are in one of the specific activities or not. And now in the second round, it's going to be that the companies only that are under one of these activities will have to comply. So I think we've got a lot of work still to go as we go through the different rounds and people get used to it. But I think overall the UAE's been very successful in implementing it, and we haven't seen too many problems. And as Warren said, we've had a big response rate. There's fairly few companies that have shirked this responsibility, and yeah, we're really happy with it and see a good place for it in the UAE environment.
Thanks very much. Josh, can I come to you now? What's your input into this?
Well, I mean, my background, as you said at the start, is I was a lawyer in the UK before I moved to the BVI, and so really my work over the last 2 years has been working with clients across the spectrum of what we deal with in the BVI. I mean, people come to the BVI for a wide variety of different things, you know, funds, from open-ended through to private equity structures, large corporate clients through to private wealth, personal investment companies. So we really have been working with all aspects of the industry to help familiarise them with the requirement. The first step is to identify whether or not you are actually carrying on a relevant activity, and if you're not, then it's very easy. I think when the other speakers have been speaking, that when we're talking about the notification, the reporting requirement, although every BVI company has to file a report, for some companies that is just a nil return saying I didn't do a relevant activity. So it's very much like the UAE system in a sense. And then the more full-blown reporting, where you're reporting on all of the different criteria to show how you demonstrated substance, is only then for a subset that are carrying on the relevant activities, and the reporting varies depending on what you're doing.
Can I just stop you there for a moment, Josh? Your firm's developed an online tool to assist with that, hasn't it? Can you tell us a little bit about that?
Yeah, absolutely, and thanks. So I mean, this really was to ensure that every BVI company, so not just the ones that we're associated with through our fiduciary arm, but every company in the jurisdiction had access to fixed costs, you know, low priced legal advisory service. Effectively, it's a fully automated legal memo, so that every company can understand how they are classified under the new legislation and then deal with any compliance reporting obligations that come out of that. So it was personally kind of really exciting to see how much the market kind of accepted that type of product, and it's been really widely utilized. And I think it's just very helpful for companies to be able to go through that to ensure that they're not, misstepping, or they're not taking actions that they don't need to take. So it helps kind of combat the misinformation and the lack of familiarity with the new rule book.
Yeah, sorry, go on. I just stopped you just because I just wanted to know a little bit more about that tool. I'd heard about it, but didn't know very much about it. So go on then.
Sure. So I mean, that is an online questionnaire that every company, whether existing or just a theoretical incorporation, can fill out, and it takes you through an explanation of what the legislation is, right the way through to the relevant activity definitions, and a real deep dive into those in a very logical order, as a lawyer would ask the questions. And then it takes you through the tax status questions as well, so around the exemption if you have a good tax status or you're a non-resident, and then tells you effectively what your compliance and reporting obligations were. And we launched that ahead of the first compliance phase for the vast majority of BVI companies, and I think it was a really helpful tool. I mean, I know that Charlotte's companies have worked with it, for example, and I think it was a useful thing for all registered agents and clients who have to make use of.
Yes, okay. Thanks very much for telling us about that. I stopped you. You were telling us a little bit about your practical experience of the implementation in the BVI, and then I diverted with you with the question about the online questionnaire. Do you want to go back to what you were talking about?
Sure. So I think, unlike the UA, perhaps we don't typically see BVI companies used for a lot of kind of domestic operating business. So a lot of the clients that I'm working with are, in the part of the world that the viewers will be thinking about, are cross-border investment vehicles. So your classic passive holding vehicles, JVs, M&A acquisition vehicles. Latterly, we've had a lot of interest in special purpose acquisition vehicles. In the private wealth space, we typically see BVI companies use underlying trusts, and the Vista Trust in particular has been well accepted in that part of the world. And also our funds market, and for a lot of those, it's been quite simple. I think the more difficult ones are where you have an operating business, or you're into one of the relevant activities, particularly IP business. Those ones, frankly, have been more challenging, but that's very much what the rulebook is intended to achieve.
Charlotte, can I come back to you? Has that been your experience as well, that most clients are it's fairly easy for them to navigate through the process and make the decision about whether they need to file a return, and whether they need to file a nil return or whether they need to file a more detailed return in the BVI?
I would say I think at the beginning it was difficult. I think we've managed as a jurisdiction to really sort of educate our clients around it, though, to the point where they now are getting to the sort of the understanding and reasoning around whether they're in scope or out of scope. And it was a whole new world as well for registered agents, obviously, because we had to learn what to do too. So I think, obviously Josh's firm developed the online portal, which made it very helpful. Where I work as well at TMF, we developed a similar sort of online portal for our clients to navigate through and answer the questions and get an outcome which they could rely on. So that made the process a lot easier for people. And then there was sort of the second round of sort of data collection based on your outcome. And I think we're obviously in that reporting period now, and that data collection again is around working with your clients and educating them around what we need based on the classification outcome. So I think we have done our best to make it as easy as possible for something that is extremely different for obviously most clients who have BVI companies. But I think overall we definitely are getting there, and it will only become easier, I think, as time goes on. And
obviously your company deals with companies incorporated in the BVI and in various other jurisdictions as well. Has your experience been that in most jurisdictions the approach has been the same, or have you found some better or some worse?
I think
there's no real alternative for companies to go to a jurisdiction where they're going to not be subject to these requirements, is there? That, I mean, presumably people ask you that, and the answer is there's no reputable place to go to where these requirements aren't going to apply.
Yes, and if I do get asked that question, it's not the type of client I'm interested in. So I think that is true. But from my experience, and obviously TMF is in lots of different countries all over the world, and just seeing what the other jurisdictions have done, for example, Jersey or Cayman, and Cayman does specifically come to mind. They've done something similar, but a two sort of phased reporting regime, I think, which has been a little bit different to what the BVI has done. But I think generally overall, the requirements are very, very similar. But maybe on a practical reporting side, they're just a little bit different depending on what jurisdiction you're in. So I think generally it is the same.
Warren, is your experience similar? Obviously, your company's in numerous jurisdictions as well. Is your experience similar to what Charlotte just reported? And do you think it would be sensible if there was if the requirements became more similar in more jurisdictions, and so rather than becoming an EU directed program, this became perhaps an OECD directed system?
Yes, I think that all of us are trying to educate our clients as best as possible, and we were fortunate to, you know, over the last 18 months, we've had a huge amount of seminars and webinars and et cetera, where service providers and professionals have all educated us on different aspects of this. However, that has been very different. And when you get down to the nitty-gritty, it can be very complicated issues involved. So, you know, and also the people that are normally the administrators that are normally dealing with clients, one has to also ensure that one empowers all of them to deal with these type of things. So it has been a challenge. It has been difficult, and I think that the way that different jurisdictions have interpreted things, how they've defined things, has been very, very different. And if there was one system where one precedent could be set or one understanding could be had and rolled out to all the jurisdictions, it would be so much more simple for everybody to understand it. And I think even within the UAE, for example, you know, James will be testament to this, that certain competent authorities or free zones took different views within the UAE on the interpretation of a specific definition, and that even caused, you know, issues for us domestically. So, but you know, as with every piece of legislation, there will be evolution of the jurisprudence around it. So, you know, we ride at the sharp end of that, and I think that will develop and will become clearer and clearer as we go along. Because I think we're still in the next phase of the provision of the substantive test and ensuring that the clients are compliant with that, and that's going to be a whole different phase, which I think is the more complicated phase of matters.
Thanks, Warren. Can I come to you then, James, and perhaps ask you, from a sort of regulatory point of view? I think you know I'm a non-executive director of RAKICC, and so I have some familiarity with the differences of approach that are taken even within the United Arab Emirates. But do you think from a regulatory point of view it'd be sensible if this was harmonized so that it was the same in all jurisdictions? Is there any reason for it to continue to be led by the EU and apply to the countries that it's looking at, or does it make sense for it to come up to an OECD level?
I think it makes great sense. I always talk about the level playing field that we want to have out there. It's not that the UAE doesn't want to have the same rules and regulations in place. It wants to have it, and it wants to be treated as the equal to other countries for this and jurisdictions. So I think it makes a perfect sense for that. One thing that Warren mentioned is the different regulatory environments that are across the UAE, and at DMCC we've obviously started very early on in our life back in 2002 with quite a robust regulatory environment. So it's nothing new for us to be able to communicate quickly to our members and really to get them to understand what this new regulation is that's coming into place. But as you said, I think it will only work and it'll only be fair if once it is in place, that it's a trusted system and that others have to abide by a similar type of system also.
Yeah, okay. Josh, what's your view on that?
Yeah, no, I absolutely agree. I was reading the other day quite an interesting study which was saying, why do clients ultimately pick one jurisdiction or one product over another? I think that was in the fund space, but it's applicable to everything that we do. The number one was familiarity and legal certainty. That was the primary category. It didn't come down to price or anything else. That was the thing that people really wanted. And I think with any kind of regulatory change like this, it's really important that we continue to give legal certainty to clients. And you know, the classification, the reporting tools that we talked about, that Charlotte and I have explained, the wealth of guidance that the BVI industry as well as our regulator has put out there and made available to clients to try to achieve that in the short timetable is absolutely critical. And the more harmonization we see on some of the key kind of concepts and the reporting bit that reduces the confusion for clients, frankly, and allows us to build big tech efficient systems that minimize the impact for people's day-to-day business is frankly only going to be a helpful thing. That's particularly true when you have a global pandemic going on and people really just want to focus on their actual business rather than something which is being introduced by a regulator in their jurisdiction. It does help for us that we have one regulator for this. So we have the ITA who deal with FATCA and CRS and information exchange with the OECD generally, so they're very familiar with this space. And we're also blessed with a very streamlined, fast, efficient, predictable corporate registry where everything is done electronically. So that does help us, and we're lucky to have that. But yeah, the more that we see the rule book bed in and people become familiar with this and understand how they fall out, that can only be a good thing.
Yeah, so I mean, if the regulatory requirement is imposed everywhere in a fair level playing field type way, what would perhaps cause people to go to one jurisdiction rather than another would be the administration of that. Is that a fair comment? So if it's easier to comply in one jurisdiction, that's where you'll go, even if it's possibly a little more expensive. Yeah,
absolutely. I mean, it very much depends then on what type of client you're talking about and what sort of products is appropriate for them, because we're talking about basically the entire of the industry here. And I think this, as Charlotte said, this type of regulatory sea change is really interesting to me as a lawyer, because it means that we get to work far more with the end client than perhaps historically we used to. We get to really understand their business, and we can get in there, look at it, make suggestions, and ultimately just add value to their process. And when you're talking about price, I mean, for a lot of jurisdictions, we're considering that the initial price differential is not that great. What we excel at in international financial centres is the plumbing and the architecture that ultimately adds long-term value to the structure. And responding to this is just the latest in a number of ways of making sure that people still fit purpose.
And I mean, would it be fair to say that the more you know about your clients, the more you're able to drill down to the substance of what they're doing, the better prospects for the reputation of the jurisdiction? Because if there's a problem going on, you're more likely the further you're required to drill down into it, the more likely you are to discover it. And then if you discover it, then there are steps you're going to take, possibly disassociating yourself from the client. But that must be good for the jurisdiction in the long term, don't you think?
Yeah, absolutely. I mean, as a lawyer, obviously, I would say that, but for every participant in this industry, the last thing that you want is to find that you've got a couple of bad apples that are tarnishing the reputation of everybody. I think when we're talking about some of the differences as well, the way that BVI has done this there is a portal that our regulator has set up through the BOSS system, as Charlotte has described, but the only people who have access to that are licensed regulated BVI registered agents. So they're the ones that mediate the information flows. And if a client tries to say something which doesn't match the information that the RA has on file, you in there have got a sort of a soft verification process going on, because the RA will say, that doesn't match with our records. So that I think is helpful as well. It means that the reporting information that we're getting should be really robust.
Okay, now we're coming towards the end of the session. We've only got a couple of minutes left. One question which I've been asked, and I'm going to ask Charlotte, Josh and Warren to comment on this. James, you may think you don't want to comment on this. And that's, has economic substance been good for business? Charlotte, would you want to go first?
Yeah, I mean, locally for TMF, definitely. Obviously, as I said, the more interactions we've had to have with our clients obviously means we can charge more fees. And the classification process and the reporting processes obviously, allowed us to be able to charge for that service, as all registered agents have done. But I think that's just a small part of it. I think why it's actually, good for business is because of the value added, like Josh says, that we can do. So before, we may have just been the registered agent, but now it may be that they need full substance in the BVI, so we can assist them with obviously providing a director. We've got office space. We can do, more company secretarial work. We can actually provide that substance for them, as a service provider. That's, the good stuff, I would say. That's why you come to work every day, and it makes your job satisfying. So I think it's definitely been good business for the registered agents, and hopefully, therefore, as a result of that, you've obviously got more revenue coming into the BVI generally, and that therefore is great for the economy as well. So I think in these uncertain times, I think that's probably quite a good thing at the moment.
Warren, has that been your experience as well?
Yes, I must echo that. I mean, we've been extremely busy both in the domestic side and in the BVI side and trying to assist clients to comply with this legislation. So obviously been good for business. I think that's really the name of the game in terms of the RA business, is that we are going to be doing a lot more for less people going forward. And this is, one of the first steps in that regard. So definitely been good for our business. I think in the long term also, we're also seeing a lot of people using our services to outsource the economic substance, and also obviously creating physical presences, which they didn't do previously. And I think that's also part of the evolution of both the IBC world and Dubai, in that, in Dubai, for example, except for James's free zone, typically you didn't really need to have accounts for clients 3 or 4 years ago. Today, everybody needs to have accounts. And I think that metamorphosis or evolution of the industry, this is another one of those things. So providing the accounting services, providing the ES services, and all the requirements that go along with economic substance is obviously very good for business for us.
So, and do you think that is going to produce a business for your firm, both in the BVI and in Dubai, or do you think it's going to be confined to one place or the other?
I think that, we've been in a very fortunate position in that we have a massive, what I call smorgasbord of services that we can provide to clients. So we try and put clients in the best jurisdiction that suits their needs. For example, the BVI has access to the Privy Council. It has legal certainty. It has a huge array of professionals, and it is known to most people in this part of the world. So the use of BVI companies is not going to go anywhere. And I think all it's doing is really categorizing those companies into actually understanding that maybe this is not applicable to the vast majority of them. So they definitely will have a specific use. I think also there will be a revised sort of focus on domestic entities, and it will also provide an impetus to them as well. And, specific exemptions that have been provided in this particular legislation, where somebody is resident in Dubai, where the activities of the entity are confined to the state and they're not part of a multinational operation, due to the fact that we don't have any corporate or personal tax, that entity becomes exempt from ESR. And so that kind of treatment should also be extended to other jurisdictions where somebody is resident here, where there is no real requirement for that information to be sent back to us. So I think that there will be a benefit for both parties.
Thanks, Warren. Josh, very quickly, because we're right at the end of our session now. You got anything to add to that?
I just echo what everybody else has said, but I mean, speaking as a legal advisor, I mean, having a deeper relationship with your clients, having a better understanding of their business, and having them come to you really as a kind of a trusted advisor to help them navigate these types of changes is really exciting, and it offers you the opportunity to speak to them and to find out how you can really help them. I think, as Charlotte's kind of indicated, the challenge has frankly just been the volume of work, which is a nice problem to have for us.
Good. Okay, thank you very much. That's the time that we've got. So, ladies and gentlemen, that's the end of this session. I say thank you very much to Charlotte, Warren, Josh, and James for their valuable input. Thank you very much to BVI Finance, who have sponsored this session, and I hope that you enjoy the rest of the conference. Goodbye.
Thank you very much, Michael, for leading that great session. I'm sure that everyone has a lot to think about now that it's concluded. So please do stick around for the next session coming up in just a few minutes, still on the platform for the Middle East Investment Summit. Thanks, everyone.